In many ways, debates over federalism after the Civil War shifted to the scope of the post-Civil War amendments and to the Commerce Clause. The Necessary and Proper Clause, however, has popped up again in the context of the new federalism, starting in the 1990s. Debates about federalism have always been important to constitutional law, but we can think of those debates as waxing and waning in at least 7 phases. First, the basic debate leading to ratification of the 1789 Constitution and solidifying a strong federalism in decisions of the Marshall Court, expanding federal power. 2. The Civil War, a crisis of federal power. 3. Reconstruction-era civil rights decisions limiting the scope of the post-Civil War amendments restricting federal power. 4. Pre-New Deal Commerce Clause jurisprudence suggesting a modest role for federal power. 5. Post-New Deal Commerce Clause jurisprudence significantly expanding federal power. 6. Civil rights era decisions reinvigorating the post-Civil War amendments, expanding federal power. And 7. The new federalism, spurred by conservatives, starting with decisions in the 1990s, restricting federal power. I would suggest we are still in a fluid period regarding the new federalism. As the court continues to shift conservative, we're likely to see more decisions restricting federal power, certainly in the economic arena, but also concerning civil rights. An interesting dynamic in the new federalism has been Justice Kennedy's role as a swing vote between the court's liberal and conservative blocs. On civil rights issues, Kennedy tended to vote with the liberals in favor of more expansive federal power. On economic issues, he tended to vote with the conservatives in favor of restricting federal power. Of course, like any heuristic, this framing oversimplifies history, but it does, I think, help highlight the connection between specific doctrinal questions and broader philosophical views about federalism. U.S. Term Limits v. Thornton, a 1995 case, is a good example of how the Necessary and Proper Clause could figure into ongoing debates about federalism. The issue there was whether a state could enact term limits on candidates for the Federal House of Representatives. What do you notice about differences between the majority, concurring, and dissenting opinions in that case? Which of the opinions seems more persuasive to you? U.S. v. Comstock, a 2010 case, concerned a federal statute that required states to take responsibility for the civil commitment of certain persons deemed sexually dangerous who could not be convicted criminally because of an insanity defense. The statute in Comstock is an example of cooperative federalism, under which the federal and state governments share legal and budgetary responsibility for some area of concern. Tensions can arise when the federal statute requires states to take on budgetary or other resource obligations. A state might have chosen to structure its priorities differently or not to take on some obligation at all. In his majority opinion, Justice Breyer first seems to suggest that federal regulation under the Necessary and Proper Clause should be subject to a rational basis test. He says that, in determining whether the Necessary and Proper Clause grants Congress the legislative authority to enact a particular statute, we look to see whether the statute constitutes a means that is rationally related to the implementation of a constitutionally enumerated power. As you will learn as we work through this semester and next semester, a rational basis test in constitutional jurisprudence is a very low bar. Justice Breyer then goes on, however, to list 5 factors that should be considered under a Necessary and Proper Clause analysis. 1. Is the enactment rationally related to the implementation of a constitutionally enumerated power? 2. Is the enactment more than a modest addition to existing federal law? 3. Is the enactment reasonably adapted to Congress's power to act? 4. Does the enactment properly account for state interests? 5. Are the links between the enactment and an enumerated power too attenuated? It's unclear whether Justice Breyer's opinion establishes a basic rational basis test or a 5-factor test, or whether the 5 factors are simply examples of what might or might not pass for a rational basis test. Note also the concurring opinions by Justices Kennedy and Alito. Why do you think Alito joined the majority but wrote a separate concurrence? Finally, notice that the 2 originalist justices dissented. What do you think is their primary concern?